Button. So now we are waiting for the stream to fire up across the internet. If you're not familiar with the broadcast, we do multi-stream. We are on Facebook and Periscope and Twitch, but YouTube always takes a minute to get started, but it looks like we're live, so let's get rolling. Hello, my friends, and welcome back to yet another episode of Watching the Watchers Live. My name is Robert Gruler. I am a criminal defense attorney here at the R&R Law Group in the always beautiful and sunny Scottsdale, Arizona, where my team and I, over the course of many years, have represented thousands of good people facing criminal charges. And throughout our time in practice, we have seen a lot of problems with our justice system. I'm talking about misconduct involving the police. We have prosecutors behaving poorly. We have judges not particularly interested in a little thing called justice. And it all starts with the politicians, the people at the top, the ones who write the rules and pass the laws that they expect you and I to follow, but sometimes have a little bit of difficulty doing so themselves. And so that's why we started this show called Watching the Watchers, so that together with your help, we can shine that big, beautiful spotlight of accountability and transparency back down upon our very system with the hope of encouraging some meaningful change. And we're very grateful that you are here and with us today. Of course, we got a lot to dive into. Today is day 2 of the Derek Chauvin Trial. Derek Chauvin / George Floyd. This is now taking place in Minneapolis. And there was a little bit of activity today. We have 3 jurors who have been seated onto the jury panel. So we're going to break down what happened. Now, we are going to talk a lot about some of the jurors who were not chosen, because there's some interesting themes that we can pull out of this entire process. Before we get into any of the juror selection, there were a couple of issues that the judge had both sides discuss today as it relates to the motions in limine, which, if you recall yesterday, we did a sort of a crash course on those. These are motions that are submitted by the attorneys on both sides to dictate and decipher what the rules will be for the rest of the trial. A couple of interesting cases or interesting motions were submitted today. We're talking about a potential state government witness, goes by the name of Genevieve Hanson. So there was some conversation about what she can testify to. You may remember her. She was somebody who was there on scene with George Floyd during the entire altercation. She sort of came across the street, started to shout at the police officer. So I want to break down what's going on with her. We're going to hear from her again. Then we have 3 jurors who were seated, and I want to give you some of the details that we know thus far about them. Now, they're going to all be kept secret and under seal. We're not going to know their identification or their identities or anything like that. But we do have some information just based on the testimony that they gave, and some information from a reporter from the Star Tribune. So we're going to talk about all that. Then we're going to talk a little bit about a free speech case. Sorry about that noise there. A free speech case from Alex Jones. Alex Jones, yeah, the InfoWars guy, the guy who's been banned from every single platform in this country. We're going to talk about him because he has a new case in front of the U.S. Supreme Court, and the Supreme Court has just asked for a response from the people who are involved in the underlying litigation. So I want to break down what that suit looks like. Of course, on this channel, we've talked a lot about free speech, huge proponent of it, and so I like people who are fighting to protect that, regardless of what you think about Alex Jones. He is somebody who is very vocal. He's using a lot of speech, and he uses it freely. So we want to see what this lawsuit looks like in the Supreme Court. Then we're going to change gears, talk about the big Gretchen Whitmer over from Michigan. She is now under, there's a prosecutor out there who's saying that he might be thinking about criminal charges for the nursing home debacle that they've got in Michigan. So not only was this happening out in New York, but also Michigan apparently was just throwing grandma in back with the COVID patients. Not so good. Now there is a prosecutor there talking about filing criminal charges. We'll see if that goes anywhere. But we have a couple statutes we want to break down, tell you more about that story. And then lastly, you may have seen this story floating around on the internet lately, but there was a very interesting court proceeding that took place. I'm not sure exactly when it was, very recently, where the defendant, the person who has been being charged with the crime, is calling into the court proceeding from the same house, from the same residence that the victim of the case is also calling into court. Of course, they're not supposed to be in the same building. That's not good, because when you are charged with assaulting somebody, one of the release conditions, traditionally speaking, is that you don't go back near that person again. They want to keep you separated. So if you're calling into a Zoom proceeding while the victim of the crime is in the same room, not so good. So I want to show you what happened on that. And we got a lot to get into. So let's get rolling. Before we do, I want to invite you over to our platform called Locals, watchingthewatchers.locals.com. As we go through all of those different segments that I just outlined, please feel free to ask questions on that platform. There's a live show thread on Locals, and you can just chat with other people there. And if you have a question about anything that I'm covering, feel free to just throw it in that chat box and we'll address it here on the show. Miss Faith is right back there clipping everything and throwing it into my slide deck. It's also a good place to just hang out and meet other people. We're working on growing that community, so thanks for those of you who are already over there. We're also simulcasting today here on Clubhouse, and so immediately after this show is over, we're going to jump right into Q&A exclusively on Clubhouse. So if you're not on Clubhouse yet, you might want to think about it. Miss Faith can help you get signed up if you need an invite. Just reach out to her, send an email over to tips@rrlawaz.com. She can help you out with an invite. But it's a good platform, and we can have live Q&A back and forth with one another. The room club link is in the description wherever you're watching this channel. So join us over there after the show. If you're on Clubhouse listening, please join us as we go through the slides over at rrlaw.tv. That will forward you right over to our YouTube channel. All right, so enough of that. Let's get into the news. Derek Chauvin, this was day 2 of his trial, and the court started jury selection today, which was a little bit surprising to me. Now, they said that they were going to do that, but I was sort of under the impression that maybe we might hear from the Court of Appeals or the Supreme Court there in Minnesota that would do something to rock the boat a little bit, but that is not happening. It's not happening. Nobody from the Court of Appeals or the Supreme Court has said anything. And so this Judge Peter Cahill, is trucking along, and we actually got 3 of 12 jurors seated today, which was kind of a big surprise to me. But that is a good thing. That means this thing is on the tracks. They're moving forward. Nobody's telling them to stop thus far. So we can just presume that it's going to continue forward. And so let me give you the outline of what the current field looks like. So this is a diagram where we've got on the right side, we've got the defense team, and we learn, you see there are new faces here than there were yesterday. We still have the judge. Today he took his mask off, so we have a better picture of him. Same with Eric Nelson, Matthew Frank also. So Eric Nelson is the defense lawyer who's representing Derek Chauvin over here on the defense side. We also learned that Eric Nelson has an assistant. Don't know her name just yet, but she was in the back of the courtroom helping with jury selection. Jury selection is sort of a big task. You're consuming a ton of information very rapidly. And typically, if you're an attorney, you need somebody to help with writing down the information. You're listening, watching body language, and you need somebody else to help digest that information for you. And so Eric Nelson, the defense attorney, had his assistant there. We don't know her name yet, but she's there in the courtroom. On the prosecution, we have an appearance of several other people today. Yesterday, we saw the Assistant Attorney General, Matthew Frank, who was really leading the case. Then today, we saw this new guy, Sundeep Iyer, and this other guy, Steve Schleicher, were also speaking today on behalf of the government. We learned that they also have assistants. So this woman here was in court, and this gentleman here was also in court, but we didn't get their names yet, so we just don't know exactly who they are. So we're going to go through a couple of the motions in limine, but then we're going to talk about this jury selection. And so now today we know that we have 3 of the 12 jurors who have been seated, and we're going to break down what that looks like. But before we get there, a couple issues that I wanted to pause on as it relates to the motions in limine. And so motions in limine are very important. These are dictating what the rules of the trial are. Now, a lot of people are just sort of watching this stuff and they're saying, oh, it's just pre-trial, boring, mumbo jumbo. No, this is where trials are made and broken. Here, when the rules are outlined. And so these are some very, very important issues that I think are being settled right now that a lot of people in the media are just glossing over. Everybody's talking about the jurors. Oh my God, there's a white guy on the jury. Oh my God, there's a lady of color on the jury. Okay, so we got that. We're going to do that analysis also, right? Can't get away without commenting on any of that. So we are going to get there, but a lot of this stuff was pretty powerful that took place earlier on today in the pretrial discussions on motions in limine, dictating what the rules are. If you pass go, do you collect $200? Yes or no? The judge is going to decide what the rules are in his particular courtroom. And so we start off with this segment from the defense attorney, Eric Nelson, who is talking about training versus policy. Okay, now this is sort of a in the weeds conversation about this, but last night on Clubhouse, we were diving into this. What if the policy manual for the Minneapolis Police Department says that you can put a knee on somebody's back? And I think Timcast and some other streams, other YouTubers were showing you policies from the Minneapolis Police Department that said very clearly that you can put a knee on somebody's neck or on their back, or you can use it as a brace to hold somebody against the ground when you're trying to detain them. And we've covered some of this previously. We talked about this on this channel. I found a CNN article that said, yeah, the knee restraints are allowed. Those are permissible. But we also had some some questions about it. I went to go find the policy myself, and lo and behold, they were off of Minneapolis Police Department's website. A lot of revisions. The new documents now say, yeah, absolutely nothing to do with the knee on the neck, nothing at all. They just scrubbed it clean. And so now what they're talking about in court is, of those issues that I just sort of dumped out there on you, what of those can we discuss? What can we bring up in front of court or in front of the jury? And so the judge is going in here and talking about kind of two different things. The defense attorney and the prosecutor, so the government and Chauvin's attorney, they're duking it out over, well, what if the formal policy says this? Then can we talk about it? Or what if the policy says that? And what if the policy was changed after George Floyd died? Can we talk about those policies? Can we talk about the fact that the government modified their policies? And neither side really wants to talk about that. The government doesn't want to talk about it. The defense doesn't want to talk about it. And the reason, I think, in my opinion, why, is if the defense if the jury knows that the defense is concerned that they changed their policies, well, that might show that their client did something wrong and they were sort of in violation of a policy. Even though the policy wasn't in effect at the time, it still tends to show that maybe what happened was in fact bad because they changed the policy, right? It's like, if you ever see a warning label on anything, okay, usually that warning label didn't exist until somebody tried that thing. Okay, when it says here, don't eat this corkscrew. Do you think that they were just bored and put that warning on that? No, somebody tried to eat that corkscrew. That's why they put it on there. So here, they're saying, well, they changed the policy. That means that something bad happened previously, so the defense does not want that in. Similarly, the government doesn't want it in because if they're allowed to talk about a policy that allows the knee on the neck, well, then the defense can say, see, it's policy. He easily could do it. So the prosecutor doesn't want that in. The defense attorney doesn't want it in. So they kept all of that out. Now they're having a conversation about training. So the judge, really, to his credit, I think he's doing a great job thus far, is saying that, well, we're not really going to care much about the policies, whether it changed, whether it happened before, whatever. We're going to go right back to the training and experience. If they got training, then they're going to be allowed to talk about the training they received. But they're also not allowed to comment on certain other things. So let's get into it. There's an interesting little snippet here. You're going to hear somebody from the government is now saying that Chauvin, they're using Chauvin's name. They're saying Chauvin and Chauvin and Chauvin. And the judge says, whoa, hey, it's Mr. Chauvin, all right? It's Mr. Chauvin. We use titles in this courtroom, so the judge gets a little bit snippety with him, which is always fun when the government is snippety at the prosecutor. So let's dive into this first clip. Here is Eric Nelson, and here it is.
Yes, identify yourself for the record, please.
This is Sundeep Iyer for the state of Minnesota. There is one objection we have to Chauvin's motion 19. The state opposes the motion to the extent it precludes testimony not just on subsequent changes to MPD policies, which we agree absolutely should be excluded, but also on MPD policies on which Chauvin was trained, but that might not have been in effect at the time of Floyd's death. Policies on which Chauvin was trained are definitely relevant.
It's Mr. Chauvin, please.
Whether Chauvin had the requisite mental...
Mr. Iyer? Mr. Iyer? We refer to everyone by title, so it's Mr. Chauvin, please.
Oh, my apologies, Your Honor. So this court recognized that whether Mr. Chauvin was trained on a particular policy is relevant in determining whether he had the requisite mens rea, and it recognized as much in the probable cause order.
All right, so that's part of the video. That's normal.
Follow training would be potentially prohibitive, for example, of a gross deviation from the standard of care, of whether he consciously took a chance of causing death or great bodily harm, and of potential recklessness. And so for that reason, the state respectfully asks that the court deny the motion to the extent it seeks exclusion of training Mr. Chauvin received that might not be reflected in the MPD policies that were in effect at the time of Mr. Floyd's death.
So what I hear you saying is it was not policy, but they were training on a certain topic. Mr. Chauvin received that training, and you want to be able to comment on that even though it was not firmly in policy yet.
That's correct, Your Honor.
Mr. Nelson.
I'm trying to figure out if you're talking to me or him. Sorry, this is an awkward arrangement.
True.
Because I see 1, 2, 3, 4, 5, 6 of 7, 8. So I apologize, Your Honor. I'm not trying to be glib. It's just
No, actually, I'll address you specifically if I need to. Mr. Iyer, is that kind of what you're saying?
Yes, Your Honor, it is.
Okay, Mr. Nelson, do you have...
Yes, Your Honor. In terms of training through the Minneapolis Police Department, that's obviously going to be a significant issue throughout the course of Mr. Chauvin's career. What our motion specifically was addressing is any policy changes subsequent to the incident at question here. We are in agreement that those policies, I think we're both in agreement that those policies should not be referenced during the course of the trial, those changes. With respect to his other training, I guess I would seek clarification from counsel simply because there are training methods that have been approved. If we're talking policy versus training, I guess that's the question that I would have.
All right. You are, Mr. Iyer, you are essentially trying to get in the training that he had. I don't see any reason why that would not be relevant. I think that comes in regardless of whether it's been embedded in policy or not. So I think we can probably deal with this when it comes up, drawing the lines on appropriate testimony. But if it's training Mr. Chauvin received before the death of Mr. Floyd, I think we have to recognize that that is relevant, and I would allow it regardless of policy. All right, does that answer the question, Mr. Iyer?
Yes, it does. Thank you, Your Honor.
All right, and the next.
All right, so that was really in the weeds. I know not the most interesting clip, but it is important because they're having conversations about what can come into court as it relates to the policies. And I think this is a pretty important distinction. When we talked about this as one of the key defenses, specifically in my defending Derek Chauvin, defending the indefensible, and that was really based around the premise that the government here has to prove that this was imminently dangerous, and if they're going to go into the third-degree murder charge, that there was culpable negligence and all of these other things. I may have those flip-flopped. But the point is they've got to prove the evidence. It's their burden to prove it. And so I was saying that one of the defense attorney's options would be to show it's not dangerous. It's not eminently dangerous. It's not culpable negligence. Why? Because it's a part of the policy. It's a part of the manual. And it sounds like that may or may not come in based on the testimony that is presented in front of the court. So the judge is saying, well, we're gonna kind of deal with that when it comes in front of us. Of course, we're going to be able to talk about the training because that person received the training and it's relevant to their testimony. If they were trained a certain way and they're trained to put a knee on the neck, then well, the policy doesn't really matter because it's that first person account. It's their personal testimony and they're subject to cross-examination. So I think the judge did a very nice thing here for both sides. And he said, well, we're not going to bicker about the policy stuff. We're just going to talk about the witnesses' firsthand experience, what they received in regards to training in court. And it was a pretty uneventful discussion there. Both the defense and I think the prosecutor, neither one of them really got what they wanted. And the judge said, well, we'll just deal with it when it comes up. And I think it was sort of the first hint that this judge is pretty fair, pretty even-handed to both sides of this. Didn't see much here. Now, who was that other guy who popped into frame on Zoom? Hadn't seen him before or heard about him. And looking into him a little bit, he's this guy. He's actually a private attorney. Goes by the name of Sundeep Iyer, or Iyer, something like that. And he's a senior associate over from New York in Washington, D.C. with this firm called Hogan Lovells. And so he is not an actual prosecutor. He's somebody who focuses on appellate litigation and dispositive motions in federal and state court. He's briefed numerous cases before the U.S. Supreme Court. You can see sharp guy, went to Yale Law School, went to Harvard undergrad, admitted in New York, D.C., and Maryland, multiple court admissions to different appeals courts. And he's in the litigation, arbitration, and employment division at this private law firm. And so he's just working on this case sort of independently of what he does for his day job. In 2014, he also received some sort of a scholarship or a fellowship awarded to support work towards a JD in law at Yale University. Received this over from the Paul and Daisy Soros Fellowship for New Americans. Don't know if that has anything to do with George Soros, but this guy, born in Jersey, son of Indian immigrants, came to America in the 70s, and he graduated from Harvard, and on and on and on. Now he's studying for JD, so he looks like he graduated from from Yale in 2016, Harvard in 2011. So smart guy, and he's on the government's team moving forward. So that's the latest new addition. Now let's go back and let's talk about another motion in limine. This is very interesting as well. So this motion, I think, if I can recall correctly, was submitted by the defense. So now the defense, Derek Chauvin's defense team, wants to make sure that other officers who were there can't speculate or can't comment about what they would have done. Okay, so we know that Derek Chauvin had his knee on the back of George Floyd's neck. There were many other officers there. There were the three others who got actually charged with crimes, but there were other officers who were sort of arriving after the scene. Paramedics were there after the original incident. Once the paramedics get there and George Floyd is carted off back into the back of an ambulance, we see many other officers there beyond the original four. And so what the defense attorneys are saying here is, look, you can call these witnesses, but these officers cannot speculate about what they would have done or give an opinion on what Derek Chauvin was doing. And you might say, well, that's kind of weird. If you're going to call a fellow officer onto the stand, wouldn't a pertinent question be to, what do you think? Was that murder or not? Did he kill him or not? What would you have done in that situation? And so the defense certainly doesn't want that to happen, because if 5 officers got up there and said, yeah, what Derek Chauvin did was inappropriate, and I wouldn't have used that same amount of force, not so good for the defense. So they want to make sure that this sort of testimony is nipped in the bud so that it can't be allowed to happen. And the judge kind of agrees with that. The prosecutor, not so much. Let's listen in and see what the judge has to say to sort this out.
Just because someone has received training and then in hindsight wants to give their opinion, that's not appropriate. You have experts on the training. And for example, a training officer can talk about it because they have the expertise. But hindsight observations of, I just put up the crime tape, but let me tell you what I would think about, that's not going to be allowed. So to that extent, the defense motion is granted. This does not limit expert witnesses to talk about whether the use of force by Mr. Chauvin or other officers on the scene on Mr. Floyd was reasonable or not. So experts, and even the training officers, I think, qualify as experts as to whether or not that was an appropriate use of force according to how they train. That would be allowed. All right?
Thank you. Then.
All right, so the defense actually won that one. I think the judge is saying that, yes, officers can't come up, they can't put up the crime tape and say, oh, this is all cordoned off, and then give an opinion about what happened, because they're just lay witnesses. They're not firsthand knowledge. They don't have a firsthand account of anything that took place there. So it would just be sort of speculative opinion if another cop just sort of took the stand and said, yeah, I think that was wrong. It's too speculative. But the judge does say, well, expert witnesses, they can testify, of course. If somebody is watching the scene after the fact, they are qualified as an expert. They have gone through additional schooling, training, certifications, credentialing, whatever that is, and they are now allowed to give testimony about that because they've been certified as an expert. But he also goes to say that other officers who are training officers who would qualify as an expert witness. So in other words, if Derek Chauvin had a supervisor who taught him regularly how to train or how to subdue prospective suspects, then that officer could come in and give an opinion about whether he used excessive force or whether what he did was outside of the policy, because that person is credentialed to comment on that. But the other officers are not. They're just lay people, so they cannot give their opinion on that. And so that is sort of narrowing for the defense, for Derek Chauvin, some of the allowable testimony, which serves the defense. So the judge agreed with the defense on that motion. We have another motion in limine before we get into jury selection. You may remember this scene from the body camera footage that was released. I want to thank Jeremy Matrita over on locals.com for posting this. Made it very easy for me to scrub back through this video. Thank you, Jeremy. And what we see here is this is the scene from the side of the road. George Floyd is, of course, under this officer, under his body. You can see he's not in the frame. You can't see George Floyd's body here, but he's laying down right now. There are a lot of other individuals sort of on the right side of this photo shouting at the officers from the sidewalk. And this woman comes walking across the street, and you can hear her saying something like, it's hard to make out, but basically she's shouting at the officers, you're killing him, check his pulse. And it turns out she's a firefighter. She's somebody who knows how to identify people who need help, who has the capability, the medical credentials to resuscitate people and all of those other things. And so now they're saying, well, what can she say? So they're trying to hash out these rules and talk about what she is allowed and not allowed to say. And you may be asking yourself, well, what do you mean? She can talk about whatever she wants. But what about if she says something like, I could have saved him. If you would have let me there, I could have saved him. Whoa, that's pretty volatile. Is she qualified to make that statement? Let's see what the judge has to say.
Back to number 21. The defense is seeking an order precluding a witness named Genevieve Hanson, who is a Minneapolis firefighter who was present at the scene, from offering speculative testimony that her intervention would have saved his life or could have saved his life. Ultimately, Your Honor, while we certainly understand that Ms. Hanson has certain qualifications, she's a Minneapolis firefighter, she's certainly trained in things of CPR, she may have experience in various regards. However, in this particular incident, our position is that her testimony or her opining that had she been able to intervene would have saved her life is just simply too speculative. Certainly the cause of Mr. Floyd's death is of great controversy in this case, and while she may be certified to perform CPR, she is not a forensic pathologist, she is not a physician of any nature, and whether or not Mr. Floyd's death was preventable had she been able to intervene would simply be speculative.
Does the state intend on offering that specific narrow opinion?
Real quick, so Ms. Faith just mentioned that the audio is low. I know it's low. It's not on my end. You can see here, so the court right now, they're trying to hash out some of their tech, but if you look over here, you can see that even their volume's low. Look down here, on the green knob. I mean, they're basically like at 30% volume. So it's really hard to hear. I know that. I apologize for that. At the end of the show for the podcasters, I will try to beef up the volume on the court audio, but just generally speaking, it was low audio all day, which was a little bit frustrating. But so listen intently. Tell everyone around you to pipe down for a minute so you can listen to this trial. Here it is.
Ms. Hanson could have saved Mr. Floyd.
We don't intend to offer the opinion that Ms. Hanson could have saved Mr. Floyd. What we intend to offer is her belief at the time of the incident that if she intervened, she could have saved Mr. Floyd. And the reason why that's important is because the state intends to call Ms. Hanson to speak to what she saw on the scene through the lens of her own perception and to explain the comments she made to the officers and the actions that she took on the scene. And part of that opinion, as is true with any lay witness, is shaped by her own personal experience. And in Ms. Hanson's case, because she's a firefighter, she's handled many medical calls, including calls regarding individuals who are unconscious. And so when she got to the scene, she saw that Mr. Floyd was breathing, but his breathing was heavily labored. And so based on her own personal experiences, she immediately called for the officers to check Floyd's pulse, repeated that plea over and over, and soon asked them to begin chest compressions on Mr. Floyd. And so we're only offering her narrow belief that if she was able to intervene or if someone had intervened, they could have saved Mr. Floyd in order to explain her observations during the course of the incident. And that's classic Rule 701 testimony. It's based on her observations at the scene and her own personal experiences and personal knowledge. And it's helpful to the trier of fact to understand Ms. Hanson's testimony and to understand what Ms. Hanson was saying at the scene.
I'm going to grant the defense motion to this extent. Ms. Hanson can describe what she saw. She can describe her training and experience. She can describe what she felt was indications that Mr. Floyd was in medical distress. She can indicate that she thought that at that time she thought medical intervention should have been started, because these are the things that she always does in the field. I assume as a firefighter, she goes to the scene, she sees somebody is in medical distress, and ultimately are in need of medical intervention. So she can testify to all that, and that explains her testimony. But to get to the point to make a medical testimony that she actually could have saved him is a medical testimony that she does not have the expertise, since she does not know all the other factors that are going into that. But she can say almost everything right up to that. The opinion that I could have saved him is not a proper opinion for her to testify to, but everything up to that and why she thought medical intervention was required urgently because of what she saw is certainly permissible.
Agreed, Your Honor.
So that's the court's ruling.
Yeah, and I think that's a good ruling. I think that makes a lot of sense. It's another win for the defense, but it's the right call, in my opinion. You know, she is somebody who can, as the judge said, so because the audio is low, I'll do a quick recap here. But the judge, the argument here, Genevieve Hanson was somebody who was responding to the scene. She's a firefighter. She's obviously helped treat people who are in dire situations before. So the prosecutor in his argument was saying she should be able to testify on her in a very limited basis that she could have saved him. And so this must have come out in pretrial interviews from both sides that she was going to testify this way, which is why the defense filed a motion to stop her from testifying that way, because she's not qualified to testify that way. The judge agrees that she can come up there and she can say, yeah, he looks like he's laboring, his breath is bad, he needs medical attention. She can come to those conclusions. Absolutely right. And so they can go walk all the way right up to that line. She can say that, but she cannot say that one specific phrase, I would have saved him or I could have saved him, because it's just way too speculative. And she doesn't know the full nature of the toxicology report or anything. She doesn't know anything. She could have administered aid, but not that conclusory statement that I could have saved him. Now, the prosecution, of course, wants that in because it basically shows, it magnifies the amount of negligence that the government through the police officers were responsible for. If there was a person standing there who could have saved George Floyd and they didn't do that, that doesn't look so good for their case. So the question is, well, could she have saved him? Maybe. Who knows? But she can't come to the conclusion. The judge agrees all the way up to that line, but can't cross it. So a little bit of a back and forth there. And the judge is going to kind of split it down the middle. Ultimately, I think the defense gets the point on that one, but the prosecution also can do a lot of damage with that conversation. They can say, yeah, there was a firefighter, an EMT, somebody medically trained standing right there. They can't say that she could have saved him, but they could say, for example, she could have provided medical attention to him, which is a powerful statement by itself. All right, so let's change gears. Let's talk about the jury selection now. Jury selection is very important part of the case. It can be very tedious, very boring, because you're sort of asking the same questions of every single juror that comes in. So the way that this format works is the judge will call in a big panel of people into the room. Actually, it wasn't that big. I think it was just maybe a dozen people. On the first round, when it's non-COVID time, oftentimes you'll pull in 30 people at the time, and you'll say, "Hey, do you know anybody here? Can you recognize any of these witnesses?" And you'll sort of ask questions of the entire panel. The people who have problems, they'll raise their number or whatever the format is. So here it was a smaller group of people. The judge asked them all questions, asked everybody to introduce themselves, all the attorneys, introduce yourselves to people. Okay, and then you call them up one by one, literally one by one, and the judge in private, away from the other jurors, and you ask them questions. And so we got through, I think 7 or 8 of them today. I don't recall. We have 3 people who made it onto the jury. They survived that line of questioning. And so let's go through this because it is interesting. We're going to be spending a lot of time with these people. So it's a good idea to get a good lay of the land as it relates to the jurors. So let's take a look at the rules first and foremost. In Minnesota, this comes from mncourts.gov. This is their jury information sheet. What does it tell us about juries in Minnesota? We have a grand jury, or we can have what's called a petite jury, which is used in civil and criminal trials. A criminal jury will consist of 12 people if the sentence for the crime charged is more than 1 year of confinement, which of course Derek Chauvin's will be. So we're looking at 12 jurors. 6 would be if it's a penalty of less than 1 year. These are according to the Minnesota rules. So that means we've got this panel to fill out. So this is the jury box. This is 12. The blue are going to be 12 people. So we got 6 on the top, 6 on the bottom, sort of representing the jury box. Over here, I don't recall if the judge said he wanted 2 alternates or 4. I think he might have said 3 to 4 alternates. I don't know, or if he's limited to 2. So 2 of these may be going away, and we're going to have some alternates who are going to be a part of the panel, but not part of the decision. Remember that this trial does not even start until March 27th, really in full. But the jurors still need to be seated, and they need to iron out some of the issues with the Court of Appeals and the Supreme Court and on and on and on. So they need to fill this panel, and they started that today. Let's take a look at some qualifications. Who needs to go on the jury panel? A person is qualified for jury service if he or she is 18 or older, if she is a citizen of the United States and a resident of Minnesota, and the person must be able to read or speak English, which we're going to see the first witness had some difficulties with this, or the first juror had some difficulties with this, and they must be physically and mentally capable of rendering jury service. Can't do it if you're completing parole, if you've not completed your sentence after a felony conviction or any of those other things. An eligible juror may be excused from jury service by the judge or jury commissioner if their ability to perform their jury duties is impaired or it would be an extreme hardship to them. Easily deterred. Okay, so those are the rules. First juror that we're going to listen to, this clip is a little bit long, but I wanted to play it out just so you can kind of see how monotonous this whole thing can be. So this woman is, my understanding is she is from Mexico. English is a second language. She's, a mom. She's got a bunch of kids, called into court, and she's kind of having a hard time communicating back and forth with the judge and the defense attorney here. And he's being very patient with her. He's trying to understand if she understands, because we're going to be hearing about a lot of medical stuff, things like asphyxiation and cause of death and toxicology reports and all that stuff, which is not necessarily an easy thing to understand if English is not your first language. You can talk about, how to do the routine things around your life, but if you're talking about, detailed medical information, then that might be something that is outside of your comfort zone as a language. And so we're going to see this conversation that's taking place back and forth between Eric Nelson and prospective juror number 1. And here that one is. Great.
So your first thought was, if I understand you correctly, is why me, right? Mm-hmm. Is that a yes, ma'am?
Yes.
Okay, thank you. As you were filling out the questionnaire, and it was asking you specific questions about this case and your perceptions about this case, did it concern you more because of the nature of this case versus other cases?
Yeah. Mm-hmm.
How so?
I said that case is just only I know because I saw on the TV.
Right.
I wasn't there.
Okay.
So,
I understand you weren't there, but does the profile of this case concern you?
Say again?
She didn't understand.
So there are lots of, maybe I'll rephrase my question if that's okay. There are a lot of types of cases that come to court. Sometimes it may be someone steals something from a store, right? And nobody ever hears about it, right? But this case has been in the news a lot. You would agree with that? Is there anything about the fact?
Yeah, sorry, yes.
Sorry. Is there any? But this case has been in the news quite a bit, right?
Yes.
Have you only seen one news story, or have you seen many news stories?
No, like I said, I'm so busy at work, and I'm housewife. And sometimes when I have time, I turn the TV and I watch this case because just in the TV, every day.
Every day.
Yeah.
And even since you filled out this questionnaire,
I had like they say, oh, why it has to do that, I mean.
so let me because you're saying something I think very important here, and I want to make sure I understand. Okay, you saw some videos about what happened. Is that correct?
Yeah, the news.
On the news. So you saw a video that many people have seen of the arrest of Mr. Floyd. Yes.
That's second wing.
So did you see a video of Mr. Floyd being arrested by the Minneapolis Police
Oh,
Department?
yes.
Yeah. And what I think you said is you had a reaction to that video. Would that be correct?
Yeah, I saw when that guy pulled his, I don't know, leg or knee on that, so he can breathe.
Okay.
And he asking for.
And did you form an opinion about what you saw? Is that a
Yes, yes.
Thank you. I'm sorry, it's very awkward. It's not like real life. What was the opinion that you formed when you saw that video?
My opinion is when he tell the guy I can breathe, and he still do that, And I remember when I saw another police around him, and I said, why don't say, hey, don't do that because he's gonna die. So I said, why? Just what I feel, that's not fair because we are humans, And he said, hey, I can breathe. He was on top on him, so he doesn't. He can move. He was on top, so.
Okay. So your job, if you were to be selected as a juror in this case, would be to hear all of the evidence in this case. Do you understand that? Is that a yes?
Yes.
And you may see that video again in this trial. Do you understand that?
Yes.
But you may also hear or see other videos from different angles and different perspectives. Would you be okay with that?
Yes.
Okay. The question then becomes, if you see, are you willing, let me rephrase this, are you willing to examine all of the evidence to make a determination about this case?
Yes.
The opinion that you had before, when you first saw the video, would you be willing to change that opinion if you find other information out later?
Well, it's true, Yes.
What is true?
It is true, whatever evidence.
So, again, I need to we have to be very clear here, okay? Would you be willing to re-examine your opinion today if you see other evidence that change it? Would you allow it to change your mind?
Yes.
Okay, good. Now, I'm going to just ask you some more general questions, if that's okay. All right, just to learn a little bit more about you. Okay.
Okay.
So let's.
All right. So he goes on, and you can very clearly tell, in my opinion, that there's a language barrier there that just doesn't serve the interest of the trial. And they did a very nice job, very patient with her this morning, this afternoon, whenever she was up. And ultimately, she didn't make it on the panel. Right now, she had a difficult time communicating about just some of the basic things. He said, "Do you have is this different from a different profile of a different case?" And profile, what is that, right? And you can understand that if you're going to be asking medical expert witnesses about some concrete medical advice or some detailed language there, that she's going to have a difficult time communicating it. They were very patient, but ultimately she didn't make the cut. Here is another picture. So after they were going through and interviewing all of the prospective jurors, they would break after each juror and they would have conversations about it. So this is Eric Nelson. Then we have Derek Chauvin over here and their assistant. And so they're all communicating away from the microphones, back sort of hunched over this table to have conversations about what they want to do. Do they want to strike a juror? Do they want to strike a juror for cause? A peremptory strike, meaning that they can just strike them without cause. And so they're talking about it. And then we get on to juror number 3. We're not going to go through all, I think 7 or 8 of them, but this is the last of the people that we're going to cover that are not making the panel. This one's interesting. Juror number 3, very honest. just comes out and says, listen, I can't be impartial. Are you kidding me? I saw the video. What are you, nuts? There's no way I'm changing my opinion. The judge and everybody are really trying to rehabilitate her, and she's just, no, it's not changing. I saw what I saw. Here is juror number 3.
Do you think you could put all that aside? Because, as you notice, we asked you, what have you read about or heard about the case? Because we recognize that people have heard about this case.
Mm-hmm.
The question becomes, can you decide the case only on what you hear in the courtroom?
So aside from what I've heard since my questionnaire, am I willing to put the headlines aside?
Everything you've heard before. Because you have to essentially be the blank slate, and it's okay to come in with some knowledge about the case. It's okay to even have opinions. It's even okay to have strong opinions about the case. But as a juror, you have to put all that aside. Some people will say, no, I can't do that. I've got these very strong opinions. I cannot put them aside. I cannot be, and very honestly, say they can't be fair and impartial. Some people, even with strong opinions, can say, I understand my role, and I feel I have the self-discipline to be able to do that, to put aside what I've heard before, decide just what we hear in court, and to follow the law, which obviously comes from the court.
Trying
I
hard.
think you could do that.
I definitely fall into the bucket of strong opinions.
Okay, and I noticed that on your questionnaire, there were some.
Definitely have strong opinions about the case. I think I could try to be impartial. I don't know that I can promise impartiality just based on my opinions and personal experiences. I don't know that that could be promised.
Okay, and I appreciate that's a very honest answer. And we put you in a tough spot because we say, you know something about the case, but even what you know, we're asking you to put aside. And to some extent, can a bell be unrung? All those kind of concepts. And we put you in a tough spot and say, now tell us whether you can be fair and impartial. We recognize that that's a tough spot to put you in. But we actually, you know yourself better than any of us. Do you think when it comes right down to it, that you could do it?
I don't think so.
Okay. And tell me a little bit more about that.
I think in this case, there's very clear action that was taken. And I think regardless of what kind of dress you put the action in, it happened. And so regardless of what charges are brought or what evidence is brought, I think there's already too much that has happened and too much that is just cold hard fact that cannot be ignored.
Okay. So let me put it one last way. As a juror, you can't be hoping or yearning for a certain result over another. And because if you are, either way, you shouldn't be a juror because that's not being impartial. And it's not a character flaw, it's just, based on what you've seen and heard. And
Understood.
So do you think that's still the case, that you probably...
I think I definitely hope for a specific outcome, and I don't know that that would change.
Okay. Any inquiry from the defense?
Nope.
Well, let me just see if the defense or the state has any inquiry. You may.
Yeah, so we're not going to listen to the prosecutor. So the prosecutor comes back up. It's actually this guy who goes by the name of Steve Schleicher, another private attorney who's joining the government. But we have, she goes through. The judge is like, "Are you sure? Are you really sure? I know you just said that you can't be impartial, but think about it again. Let me frame it another way. Let me just say hypothetically." And she's like, "Judge, I told you 5 times. I can't be impartial. I saw what happened. I want that guy in prison for the rest of my life." She didn't say that, but she might as well have. And the judge really just did everything he could, tried to, and this is what judges do. They want to help you understand the process so that you can make a neutral decision. Obviously, that young woman, I think she sounded young to me, is somebody who is not going to be able to do that. So the prosecutor came back up after the fact and said, "Are you sure? Are you really sure?" Because they wanted her on the jury so bad. They were trying to do everything they could to rehabilitate her. So the judge goes, "Yeah, you know what? I think we've kind of made her come full circle. We've circled back on this thing, and she is now capable of making an independent decision and being fair and impartial. And she just was not having it. So she's out." Speaking of this guy, Steve Schleicher. So we have another private attorney who's joining the government. So they're not using some of their own prosecutors. They're pulling in people from outside. We've got this guy who is serving as the Special Assistant Attorney General on A.G. Ellison's prosecution team in the trial of Derek Chauvin. He's an experienced trial and appellate lawyer. Now, some of these people may be being brought in just because of conflict of interest. A lot of conflicts there. Obviously, Derek Chauvin was an officer, so I don't mean to be glib about it. There's some good reasons why. Steve's notable investigations include security company holding, contract, NFL venue, IP theft, liaison defense counsel for corn seed developer, 65,000 plaintiffs, medical device manufacturer, former federal prosecutor, conducted hundreds of investigations, complex fraud matters, violent crime, organized crime, and the list goes on and on. His education, William Mitchell College of Law. He's also from Duluth, has a BA in criminology and political science. So, that's a little bit more about him. It sounds like he's going to be involved. And you can see what the government is doing. They're sort of segmenting their cases out. So yesterday we heard a lot from Matthew Frank, who was talking about the motions in limine. Then we brought another gentleman in, Sundar, I believe, or Sundeep. I forget his name. I apologize for screwing that name up. But it is important because he was covering the motions in limine this morning. And then this guy came out and was doing jury selection. So they're sort of segmenting their cases out and putting the best players on the field for the best plays. And this guy, Steve Schleicher, he is the first one that I have heard thus far to bring out the racism charge. So racism is already in play now that we are on day 2, and it's in the form of what's called a Batson challenge. What is a Batson challenge? This is an objection to the validity of a peremptory challenge on grounds that the other party used it to exclude a potential juror based on race, ethnicity, or sex. The result of a Batson trial, a challenge may be a new trial, comes from a case called Batson versus Kentucky, which held this type of peremptory challenge to be unconstitutional when used by criminal prosecutors. Another case says that they can do that in civil claims as well. So what does this mean? Well, when you have a jury, when you're paneling a jury, when you're going through voir dire, you have a certain number of strikes. You can strike somebody for cause, like that last woman, right? She said, "I cannot be impartial." No, are you sure? Yeah, I can. I told you 5 times already, Judge. Sorry. So they don't need to come up with a reason to strike her off the panel. She provided one on her own. So the judge can strike her. Anyone can strike her for cause. They say, "Look, she's said herself she can't be impartial, so she's gone." But there are other situations where you have what are called peremptory challenges, meaning you don't have to provide a reason. You just don't like that person. You say, "I didn't like it. I'm not gonna have to articulate it too much. We're just going to strike them off the panel." Now, of course, every single attorney has justifications for every strike. But what we saw, and the reason why this case came about in 1986, is prosecutors were striking people of color. Okay, if a defendant is on a trial, and let's say the defendant is a black male, and you start to see some potential black males go on your jury panel, and you're a prosecutor, you don't really want that to happen, do you? So the allegation in that underlying case and what prompted this Batson challenge is that prosecutors were using their peremptory strikes to get rid of people of color off their jury. If they want to get a conviction on the black guy, they want a jury box that doesn't have any black guys in it, right? And the Batson versus Kentucky case came about. And so today, what we see is the prosecutor is using that rule against the defense. So now Derek Chauvin is on trial. And you can make the reverse argument. Well, maybe he doesn't want black males on the jury. Now, his defense team hasn't said that at all, but the prosecutor is. The prosecutor is saying they are using their peremptory challenges to strike people of color. That's not so good. So the defense attorney then is going to come up and say, "That's not what we're doing. Okay, we're striking him for this reason. We have justification for it. It's not a race thing. It's because he said something that we didn't like." And the judge ultimately agrees with the defense again. So this is the attempt to bring up the Batson challenge. And this is our last clip. Then we're going to get into, I know the volume is low today, but
All right, jury number 4 has left.
I think it's a product of the court's sound system.
Schleicher, defense indicated they wanted to do a peremptory, and the state mounted a Batson challenge.
So the government just struck a witness,
Yes, for the
a
record,
juror.
The defense has made its peremptory challenge now, and it's a second person of color in the jury pool. And the state has raised a Batson challenge. And it's clear from the record that the juror number 4, identifies self-identifies as Hispanic, as did first juror that was struck by the defense. And when asked to provide a race-neutral explanation for the exercise of the preemptory, the defense, and I'll let them speak for themselves, but articulated just sort of a generalized concern that this particular prospective juror expressed strong opinions and articulated a belief that he was simply trying to get on the jury. But there's really no objective evidence of that. There's nothing in what the prospective juror said that would support a conclusion that he held strong beliefs. I believe that the juror said exactly the opposite, and that whatever beliefs or opinions he may have had, he was unequivocally willing to set those opinions aside and judge the case based solely on the evidence, or in his words, on the black and white. And further, expressing the opinion that he would have no problem setting those beliefs aside and deciding the case based on the facts and the evidence and the law. Now, I draw the parallel between juror number 4, who's Hispanic, and juror number 2, who's self-identified as Caucasian or white. Their answers with respect to these questions that were raised by defense counsel are markedly similar, if not the same. And the characteristics are very much the same, too. Both expressed a belief that they would decide a case based on the facts and on the evidence. Both described experiences in which they believe they were subjected to some aggressive police conduct when they were younger, but one results in a preemptory strike and the other does not. I understand that the motion from the court has been denied, but I do persist in the challenge.
Mr. Nelson?
All right. So the defense attorney now is going to come up. They're on the fourth juror.
Your Honor, first and foremost, the law requires me to state a race-neutral reason for striking this particular juror. I disagree that the juror did not articulate strongly held opinions. He specifically referenced in his questionnaire illegality of certain moves, certain tactics. He stated that he had formed the opinion that these officers had taken the law into their own hands, and that he had formed opinions about what had happened. Yes, this juror indicated that he was willing to re-examine those opinions, but only upon essentially providing him evidence and proof contrary to his opinions, is the way I understood him to say that. I think the difference between this particular juror and the prior juror is that the prior juror had not watched the video. He had limited his intentional exposure. He came at it from a very analytical perspective in terms of science and things of that nature. He had no preconceived opinions whatsoever. That's a significant difference between these jurors. The second reason, Your Honor, is that this juror has a specific training, and I was concerned in part that his training or his belief that in martial arts training that this was an illegal move was concerning, and it struck me as insincere. His statements that he would be willing to re-examine the evidence struck me as insincere.
All right, so the judge ultimately agrees with the defense on this one. The judge said, nope, it didn't seem racist to me. It didn't qualify as a Batson challenge. It was something that, as we just heard, the defense attorney came back out and was very articulate in saying, nope, these are the other reasons why we thought that this person should go. And if you listen to the full clip, the judge comes back out, but he goes on for another 3 minutes, and he says essentially that what the witness was doing, or what the juror was doing, was saying during his testimony that he would be willing to re-examine the evidence. And so you might listen to that and go, well, that sounds pretty fair, but it's re-examine, meaning he's already come to a conclusion that it's not in Derek Chauvin's favor. He's already decided that Derek Chauvin is guilty, but he's open to re-examining the evidence. He'll be fair and impartial on the evidence that's presented in court. Sure, I'll be fair and impartial. I'll listen to new stuff. If new stuff comes up, yeah, I'm happy to change my opinion. But that is shifting the burden onto the defense. Remember, at this moment, Derek Chauvin is innocent. So if that witness would have come forward and said, I do believe he's innocent, and I'm willing to give a fair shake to him and observe any evidence that comes into court, then that's fair game. But if you come in and you say, well, I already think that person is guilty, you're undermining the presumption of innocence, and you're shifting the burden. Now the defense has to prove that Chauvin is not guilty, rather than the government having to prove that he is guilty. And so that is an improper thing to do. It's an improper burden shift. And that is essentially what witness number 4, or juror number 4, was talking about. And the judge said, no, we can't have that. So the Batson challenge went out. When we started the day, we saw that this was our panel. So we're missing some people. Let's start filling it in. We have 3 jurors that we can sort of identify. We can't call them out by name or anything like that. We don't know their names or who they are, but we do have 3 people who are filling these seats. So let's take a look at who they are. Number one, this article came over from StarTribune.com. They're doing a great job covering all of this. The first seated juror is a white man. And so we have the white person emoji in there. And so this is sort of what I think he might look like. He was selected after being questioned at length by Nelson for a few minutes. He revealed he's a chemist who lives in Minneapolis. He says, I consider myself a pretty logical person. I rely on facts and logic and what's in front of me. Opinion and facts are important distinctions for me. And so we just picked different emojis for these things. He said he has a generally favorable view of Black Lives Matter because he added, I think all lives matter equally, but that, quote, Blue Lives Matter message among police advocates is a counter viewpoint that isn't necessary. He said he has not viewed the video of George Floyd's death. So he has not viewed it, which means he's probably one of the only people in America that hasn't seen it. After checking with the defense and prosecution, Cahill told the juror to report back on March 29th and be prepared for the proceedings to last about 4 weeks. So people were asking yesterday, how long is this going to take? It's going to take a long time. Probably all throughout April. The rest of March, all through April, we're going to be learning more about this. So juror number one we see here is somebody who's a chemist, white male, and he's got, I would say moderate level of support for BLM. Next up, we've got another witness who is a woman and a person of color, according to this article. The second seated juror, she's a woman and a person of color, originally from northern Minnesota, told Nelson that she was, quote, super excited to receive her jury summons because she realized it's her civic duty. She was eager to serve regardless of the case, but especially in Chauvin's trial, given the gravity of it. A quote from her says, it's a very important case, not just for Hennepin County, but nationwide. It's just something everyone's heard about, talked about. No matter the decision, people are still going to be talking about it. Like many of the others before her, she said that viewing the video left her with a, quote, somewhat negative impression of Mr. Chauvin. No one wants to see someone die. The woman also says she sees racial disparity in the justice system. In connection with that belief, she added that she agrees somewhat that the Minneapolis police officers at times used too much force against black suspects and has heard of those experiences from people she knows. At the same time, she considers herself to be a go-with-the-flow type, assured both Nelson and the assistant prosecutor, Steve Schleicher, that she can be open-minded about the evidence presented at trial. The woman, the niece of a Brainerd law enforcement officer, was then seated. So that is juror number two. She was a very interesting a juror when we were hearing her speak. A lot of energy, very dynamic personality, a lot of tonality in her language, and she'll be interesting. We'll see if she ends up being dispositive in this case because of her big personality. Then the third juror who was seated, we don't know as much about. This guy is a man who works as an auditor. And so for the emoji, I just picked somebody who looks like an auditor to me. An old guy with glasses, was chosen for the jury after expressing confidence that he could be fair. He saw at least portions of the off-reference video and somewhat negative view of Chauvin because, quote, someone died and that's obviously not a positive thing. At the same time, the man continued, he said he can examine the evidence from a viewpoint of the law before deciding whether or not the defendant is guilty. So we've got three jurors seated. Here is what our panel looks like. So thus far, we've got numbers 1, 2, and 3. We're going to pick back up on jury selection starting tomorrow. And we'll see how much further we can get. We'll see if we can get more than 3, because this morning started out with a lot of the motions in limine. And so we may have more time for jury selection that we'll pick back up literally tomorrow. So we'll start to fill this out and get an idea of what our panel looks like. All right, so let's jump into the questions over to from locals.com. So if you go to watchingthewatchers.locals.com, you can ask a question and it'll show up right here. Let's dive in. We've got News Now Wyoming says, question, you are the defense attorney. Does Chauvin testify to speak against intent for the second-degree murder felony requirement? So I think that Derek Chauvin has to testify in this case. Yeah, people need to hear from him about his training. They need an understanding about what was going through his mind and why he didn't move. I think the jury will convict him unless they hear from him. It's just my opinion. Traditionally, the rule is your client does not testify, period. All right, they just don't. In this case, I think he probably needs to. We'll see. We'll see what some of the evidence says. Maybe he doesn't just because of some of the toxicology stuff that we heard yesterday. Still waiting to sort of piece that together. Yesterday, we heard from the defense attorney that they found some residue of drugs and George Floyd's DNA in the back of a police car. I watched the police officer's body camera last night. Didn't really see that. but we'll see. You know, if they have a slam dunk, if they have something in their case, the defense, that they can spike the ball on, then maybe Derek Chauvin doesn't need to testify. But I think he ultimately will. I think the jury needs to hear from him about why he kept his knee on the neck for 8.5 minutes, 8 minutes and 46 seconds. If he doesn't explain that, I think they convict him. We've got JBone86 says, was the 94 crime bill a net positive or negative piece of legislation for minority communities? I would say, guessing here, I'm not in a minority community, but I would say I've represented a lot of people who've been impacted from the 1994 crime bill, along with the 1986 bill, 1984 bill, 1988 bill, many of which grossly impacted minority communities. I think the 1988 crime bill was specifically focused on crack cocaine. Crack cocaine, what community did that impact? Was it suburban white folks? No. It was inner city African American people. And the penalty there was mandatory prison, first offense. Boom, gone, locked up. So, yeah, I mean, I think if you looked at everything in aggregate, that it is a net negative for minority communities by, I don't know, by a factor of a million. You know, it's been really bad. We got mandatory minimums. We got our 3 strikes laws. We've got all sorts of drug crimes and drug laws for marijuana. People incarcerated for possession of narcotic drugs because they had some oil from a vape pen for marijuana. It's THC. It's not even any other narcotic. So it has been a disaster. Yeah. I'm not happy about it. We have Liberty or Death says, why are there private attorneys joining the government? Isn't the AG leading the team? Is it because they want to appear neutral by hiring attorneys from elsewhere? Yeah, I think it could be that. I mean, it could be that they want to just bring in outsiders so that there is no conflict of interest going on. Maybe people in the AG's office have prior experience working with Derek Chauvin. I don't know. Probably some of that, probably because some of these guys are just excellent at what they do, right? We have a Harvard grad and a Yale law graduate. We've got some other guy who's, been a former federal prosecutor. And so they've got a lot of experience and they want to bring in some heavy hitters, but there are probably some other rationales for it. You know, they don't want to sort of, this is taking place in their backyard. They all got to go home at night and they all work together with all these other people. So I think in theory, they want to bring somebody in from the outside who can help them run the case. Realtor Patty 14 says, why are they trying to change the minds of the jurors? So they're not really trying to change their minds. They're just trying to nudge them back to impartiality. Now, the prosecutor, of course, the defense attorney they're out there trying to lay out the framework of their case. And so this is an important part of criminal law that some people just overlook, even some defense attorneys overlook. But voir dire, when you're going through this, you're not just asking questions just sort of, well, we'll see, we'll just see, I'm just curious. You're establishing the theme of your case. You are going out there and you're saying, listen, every one of these questions should have an intention behind it. They're not just, he's not, the defense attorney today, Eric Nelson, was not just talking about, he asked many prospective jurors about tell me 3 things about yourself that I wouldn't know. If we met at a party, what would you tell me about? Right. And so they would start telling him about stuff. And then he would, that's sort of getting to know the jury, be vulnerable with me. Tell me about you. Okay, I know you. And then he's going to use that in his narrative, in his theme of his case. But he's also asking questions. We saw a lot of this, a repetitive theme from him saying that he was asking them about whether or not they've ever helped settle a conflict before. So have you ever helped 2 people settle a conflict? And they go, yeah, of course I have. Oh, how did you handle that? And so they would say, oh, well, I would go there and I would communicate with both sides and I would get their opinion and I would get their opinion and I'd bring it together and I would synthesize a result. And you go, okay, great. Because further down the line in the case, he's going to be talking about settling a conflict and he wants them to think about that. Okay, if there's 2 people in a conflict, which side is being reasonable, which side is being unreasonable? So he's planting the seed in their minds, in the juror's mind right now. You know how to be reasonable with people. You know how to settle a conflict. How would you handle it? So they can start thinking about their own conflicts in their own minds. Well, here, then the defense is going to show, well, as soon as the government plays the video of George Floyd, they're going to say, okay, yeah, we'll see. They came up to him and said, hey, let's settle this conflict. George Floyd started freaking out. It's going to be their frame on this, right? He's, flailing around. They couldn't do anything else. They tried to settle this like reasonable people. They couldn't. They had to put him on the ground. And so every question that they're asking of the jury, they're just digging that seed in there. So the defense is doing that. The government is doing that. They really tried to rehabilitate witness number 3, the woman who said, no, I can't be impartial at all. And the prosecutor came back out and said, are you sure? You understand that it's easy to get caught up in these things, and he was doing everything he can to sort of move her back towards neutrality. She was already in Convictville. He was trying to bring her back to neutrality land, and she just refused to do that. Now, the judge is always trying to keep people in neutrality land, but really they're not trying to change their minds. They're just trying to get them to a baseline that is even across the board, which is basically impossible. But this is as good as our system can get, and it's pretty good relative to other things. We got Ma Fox in the House, said these potential jurors seem to be eager to be dismissed from jury duty. Do jurors have to take an oath before voir dire? Yeah, they do. So they do. They swear an oath that everything is truthful. They agree. They're going to let the court know about certain things. Everything on their questionnaire is truthful and accurate and all that stuff. So the judge does that. I think today, I don't recall, I kind of zone out when the judge goes through that stuff. I think today he did it for the entire panel at the start of the session, and then sort of just asked them when they were brought up to the bench whether or not they heard that and whether they still agree to it and all that stuff. So potential jurors seem eager to be dismissed from the jury duty. Yeah, I mean, we did see that. I think there were 8 of them today. Most of them are gone. Obviously, we've got 5 who are gone, and then we've got 3 that are on there still. And it's, think about what is being asked of you to be on this jury, right? You're going to be at least on a panel from March 27th for 4 weeks. So your job, school, family life, all that's a mess. Then you've got potential violence against you. Okay, what if this jury acquits Derek Chauvin? They're going to get doxxed. They're going to get identified. They're going to get death threats. I mean, it's going to be not good. So they got to be thinking about their own personal security and their well-being. Not to mention just even if they convict him, they're going to be the subject of the spotlight for the foreseeable future. And a lot of people don't want that. They want to live in private, in peace, not be the subject of a national story for criminal justice reform for the foreseeable future. Now, there are those people who are thrilled about it. They're very excited. They want to get on the panel. They're going to write a book about it, start a blog, start a Twitter account. This is their big break. So I think juror number 4 we heard from, she's excited as hell. Yeah, baby, put me on that. I've got some justice to deliver in this country. So good for her. We have Jeremy Matrita says, I'm sure jury selection is a competition between both sides. The defense wants jurors they feel will be objective. The prosecution wants jurors they feel will lean toward convictions. It must be stressful. It is stressful. I've done a handful of them. They are fast paced typically, and you've got a lot of information that you're trying to digest all at once. So it's a skill set I think that you develop with time, but you're right. You're trying to move the needle your direction one way or the other. And there are entire industries of consultants and people who will help you pick a jury. And there are even apps for that on your iPad and stuff. Download an app so you can say, okay, white male, 35, high school education, Catholic, 2 kids, divorced, had a traffic ticket 100 years ago. All right. You got a nice little profile of that juror, and you want that for all of them. And so it can be a lot of information to digest, and it can be uncomfortable too, because you're having to sort of needle people about what they know. And sometimes people don't want to answer that. Hack Consulting says, if the defense has such a blatantly clear reasons to dismiss a potential juror and the prosecution keeps bringing up the question of racism, while it may be an attempt to keep the defense attorney honest, perhaps the reason why prosecution missed the blatantly clear reasons because they are anti-racist. Yeah, I thought it was way too early to bring out the Batson challenge. They were only on their 4th juror. The first woman, clearly, in my opinion, should not have been on the jury, not because she's Hispanic, because she can't speak English. She just happens to also be Hispanic. So, it was, I think, premature, but you're going to hear that the entirety of this trial. Racism. We hear it all day anyways. All day, everywhere you turn, everything's racist. So why wouldn't we see it in a trial? Hack Consulting says, okay, so second-seated juror wants to do her civic duty. Is it because she wants to put Chauvin into the slammer based on her formed opinions? I mean, I was excited to do my jury duty after I got out of the military that week. They ended up not wanting jurors. And I wanted to go because others tend not to want to, but I would be hesitant to be a juror because I want to be a good one. My civic duty is showing up, not being on the jury. Yeah, and I agree with you on that. I think anybody who's a little bit too eager to get involved in something is kind of the person you don't want there. You sort of hear that analogy like the best emperor of Rome is the person who doesn't want to be the emperor of Rome, right? And that's why you got to do it. Because if somebody wants that position, well, why is that? It's because they've got ulterior motives and selfish reasons for wanting that position of power, which is the same argument that you could apply to any elected politician in this country. So if somebody's really eager to get on a jury, it's like, well, why? Why? You're excited about it or what? Because this is not something to be excited about. This is a tragedy what happened here. This is a tragedy across the board. It's not anything to be excited about. We have a dead man and somebody whose life and multiple people whose lives are ruined as a result of it. You can say he deserves it or not, but it's ruined, right? One way or the other. If he's convicted, it's ruined. If he's not convicted, it's still ruined. Him, the other officers, George Floyd's family. I think George Floyd had kids. It's just awful. I don't know what being excited is about, but some people live those types of lives where this is interesting. News Now Wyoming said, I had the same opinion about his need to testify, but it is interesting to see a defense attorney share the same opinion on the need to break the rule about testifying in your own trial. Yeah, it is relevant. I think that in cases like this, in most cases, you don't want your client to testify because they're not really good at testifying, right? They're just not. You can train them. You can go through the process. They're just terrible at it. Derek Chauvin, though, is an officer. He's been an officer for a long time. He's very used to testifying. He's trained in it. He's probably testified in hundreds of trials. So he's very good at it. He knows what to do. He knows how this whole game works. And so he's not your typical witness. He is somebody who's got a lot of experience in this. And because it was his knee on the back of George Floyd's neck, I think that he has to explain that. He's the only person who can do that. So I think they got to put him up there. Now that I think about it, I think he has to get put up there. Liberty or Death says, if I get called for jury duty, can I use the excuse that I will miss my finals if I have to sit on the jury? I would tell a judge that, but I don't know what the judge is going to say, right? Maybe he'll commiserate with you. Maybe he'll say, well, yeah, I had to go to law school too. So you're excused there, Liberty or Death. Or maybe he'll say, just call your professor. Tell him, if you sit in my trial, you should get credit for that and not take the final exam. Use some negotiation powers. See if you can kill two birds with one stone. Get some good jury duty experience. Don't have to take a final. Well, there you go. All right. So those were great questions over from locals.com/watchingthewatchers or watchingthewatchers.locals.com. Nice, awesome community over there. I want to invite you to go join us. All right. So that's it for the Chauvin trial. Let's change gears. Alex Jones, you may or may not know, he's been banned almost everywhere, so maybe you don't know him, but he is taking a free speech issue up to the Supreme Court, and it has now been docketed, and they've set a response deadline. So you may remember this. Alex Jones, of course, the purveyor of Infowars.com, very provocative guy, talks a lot about conspiracy theories, talks a lot about the news that many people think are conspiracy theories, but no, that's just the news. He also talks about sometimes, little things that can be very provocative that lead to him being canceled. And that was the case back when he was talking about Sandy Hook, that shooting that took place many years ago that he said was essentially fake. And so this article came over from newstimes.com. They give us some background here. Alex Jones argues that Blood on the Streets rant against the attorney of the Newtown families was protected free speech. And so this happened some time ago, this Newtown family story. And it says here, extremist Alex Jones has appealed to the U.S. Supreme Court, arguing that his infamous rant, now called the Blood on the Streets rant, against the attorney representing the families who lost loved ones in Sandy Hook was protected free speech. There's a little bit of a backstory here, but Alex Jones goes on these mega tirades, and he says a lot of provocative things. I mean, I think I heard him say one time that there were interdimensional space aliens who were reptilians who were populating our Congress or something like that. I mean, he was on the Joe Rogan show. He had a little tequila, had a little marijuana, and then boom, the guy's off for like 4 hours. It's hilarious. It's excellent entertainment, by the way, but it's not available anymore because he's been banned from virtually everything. So back when we had the Sandy Hook shooting, one of his conspiracy theories was the allegation that the whole thing was faked, that everybody was actors and the whole thing was orchestrated by the government as a false flag attack in order to pass some gun law registration or something like that. Obviously not true. Obviously, that's not something that I endorse. I don't believe, like Alex Jones does, or I think he's modified his opinion now. That was a prior opinion, and now he's saying, yeah, you're right, it did happen. I'm sorry about that. But what he is saying is that in prior litigation, he was found to be responsible for defamatory statements, and he was sanctioned to pay a bunch of money. He's taken that up to the Supreme Court and saying, no, it's protected free speech. If I think that this was a fake thing, I should be free to say it. And so now that we have a little bit of a backdrop to that story, let's get back into this. So he says it was protected free speech. Norm Pattis, high-profile New Haven attorney, calls the sanctions that Jones received back in trial court in 2019 an unprecedented attack on freedom of speech, a direct frontal assault on the First Amendment itself, because what Jones did not constitute a legal threat. And as you know, on this channel, we talk a lot about free speech. I think that speech in and of itself is not dangerous speech. I know it can be offensive. I know it can be insulting. I know it can be hurtful. I know it can trigger people. But I tend to think that people should be able to say what they want. If somebody thinks something is a bizarre conspiracy theory, they're free to express that, because that's what the First Amendment protects. It protects hate speech. It protects dangerous speech. It protects the speech that people don't want to hear, because you don't need to protect the stuff that everybody's okay hearing. You got to protect the dangerous stuff that pushes the line to the margin. Unless, of course, there's an articulated exception there. You can't yell fire in a crowded theater. You can't make a true threat towards somebody. Those types of things are not protected speech because they implicate other principles and other rights and remedies. You are protected from being trampled to death in a crowded theater because somebody yells fire. Okay, but if somebody thinks something and they want to express their political opinion or their interpretation of facts and events, I think that should be protected. And so does Jones's lawyer. His views on the judicial process and the conduct of its various participants are core political speech protected by the First Amendment, regardless of whether he expresses them with Shakespearean eloquence or with quintessential American vim and vigor, he wrote in the appeal. Courts are not above the Constitution. They can transgress on constitutional liberties just as readily as the legislative or executive branches, particularly when they regulate the speech of those subject to that jurisdiction. Jones' appeal to the highest court in the country aims to overturn a decision by State Superior Court Judge Barbara Bellis that denied Jones what he considers a key line of defense in a defamation lawsuit brought against him by an FBI agent and 6 families who lost loved ones during the 2012 Sandy Hook shooting. Bellis's sanction, which was upheld by the Connecticut Supreme Court in July, came after a Texas-based businessman went on his InfoWars broadcast with Pattis and claimed someone had embedded child pornography in Jones's emails that were turned over to the Sandy Hook families as part of the pretrial discovery process. Pattis argues in Jones's appeal that his call to arms in his rant was overwhelmingly hyperbolic, and that the only threat, if any, that Mr. Jones levied at opposing counsel was that of legal action. But by Wednesday, the families had not filed a response yet to Jones's appeal. Mattei expressed confidence in the lower court's ruling. Court after concluded that Jones has engaged in a whole picture of bad faith litigation against the plaintiffs from Sandy Hook. We expect the U.S. Supreme Court to see it the same way. Jones's appeal is the latest development in a handful of defamation lawsuits in Texas and Connecticut by families who lost loved ones in 2012 as a gunman shot his way into the Sandy Hook Elementary School, killed 26 first graders and educators, which was just a terrible story. I was still in law school when that happened. And it's just awful. So this is now sitting at the Supreme Court. Here is a screenshot from the docket. You can see this was docketed February 19th, so a couple weeks ago. It's Alex Emmerich Jones versus Erica Lafferty, 2021 case. Decision from the Supreme Court of Connecticut is now being appealed. Rehearing from the lower level court looks like that was denied back in 2020. And we have the petition for the writ of certiorari was filed February 12th, and there was a response date of March 22nd. So right before the Derek Chauvin trial is supposed to start. And so we want to go through this briefly. I think we all kind of know where this is going to go, but here is the petition for a writ of certiorari that was submitted into the U.S. Supreme Court of the United States. It is InfoWars, Alex Jones, Free Speech Systems, InfoWars Health, and others, Prison Planet TV, versus all of the people that we've already spoken about. Erica Lafferty, who we're going to learn is the daughter of a mother, the daughter of the principal who was at Sandy Hook, who got killed, along with all of these other people, of course, who are sort of survivors of the people who were killed. Petition for a writ of certiorari filed by Norman Pattis, counsel of record. This is Erica Lafferty over from Twitter. She is the daughter of a woman who was the principal in Sandy Hook. And so now she's sort of an anti-gun or a gun reform, however you want to say it. Here's on her Twitter: background check, save lives. I am one of the 93% of Americans who support background checks on all gun sales. Okay, so sorry for her loss. Born 1985, same year as me, good year. But we're on different sides of the gun conversation. That's all right. So she's a party to this lawsuit. And these are the questions that are presented. So this is from Alex Jones's petition for a writ of certiorari. And let's go through it. We're going to go through it briefly. Here are the main questions. They say American courts possess inherent supervisory authority over their proceedings. So courts control the proceedings. They exercise that authority through their orders and sanctions, including civil contempt. They do not, however, possess unlimited authority, as the U.S. Constitution places limits on the exercise of their inherent power. Connecticut trial court sanctioned Alex Jones for extrajudicial statements, despite acknowledging that those statements were made in the course of a television and radio broadcast, that those are entitled to constitutional protection. The Connecticut Supreme Court altered this court's incitement and true threats exceptions to the First Amendment and functionally created an entirely new First Amendment exception that categorically applies to litigants simply because they are litigants. So what they're saying is, when Alex Jones was involved in litigation, he then said something that was now considered by the Supreme Court out of Connecticut to be off limits, an exception. He can't say those things. And so they're going to sanction him for saying those things. He's saying, no, it's First Amendment. I'm allowed to say those things, even if I'm in the middle of litigation. Whether the questions that the court is to be considered is whether a litigant's extrajudicial statements can be sanctioned when the First Amendment otherwise protects his speech and where there was no order providing prior notice of what speech was sanctionable. So if you're in the middle of a lawsuit, can you go on your TV show and call your opposing party a moron? Alex Jones saying, yeah, you can, in fact. And the court, according to Alex Jones, is saying, he's saying that we had no notice that I couldn't say those things. So normally it's protected free speech. Just because I'm in litigation doesn't make it less protected speech. Supreme Court, what do you have to say about that? Question number 2, whether a trial court's warning of the possibility of imposing the same criminal sanctions on a litigant for an unrelated matter is sufficient notice that a subsequent matter under the 14th, for a subsequent matter under the due process clause. So another question there, parties, we already covered those. Corporate disclosures, covered those. Petition for a writ of certiorari. First Amendment guarantees freedom of speech. We know it's not absolute. Court may impose sanctions for speech falling within certain prohibited categories, things like fighting words, incitements, true threats of violence, incitements to violence, and defamation. Those are all exceptions. Courts have the authority to enforce their own rules, as in cases of attorney discipline for speech in violation of those rules. However, little case law exists on the power of courts to sanction litigants for extrajudicial statements, particularly for otherwise protected speech made outside the courtroom or lacking a connection to a court procedure that is uttered over the course of a television talk show. In this case, Connecticut Supreme Court sanctioned Alex Jones, and they refused to rule on a motion to dismiss a lawsuit. The sanction was entered without meaningful notice, no opportunity to be heard. Neither Jones nor the rest of the petitioners received any notice about what the trial court would allow and not allow. They call this an unprecedented attack on the freedom of speech under the guise of the inherent supervisory authority over the litigants. So they're saying that Connecticut Supreme Court is sanctioning him for making statements that were made during the course of the litigation, and they're calling it their inherent supervisory authority, which you might say, okay, well, the court can govern that, right? They can govern the motions, the proceedings, and how this unfolds in their court of law, but they didn't provide notice to Alex Jones that he couldn't go on his TV show and rant and rave. The Connecticut Supreme Court also crafts a dangerous new course in the First Amendment law by creating vague, highly generalized exception to the First Amendment protections, establish a basis for denying constitutional protection in unpopular and hateful speech. And then this goes on. Opinions, we've got jurisdiction. You can see here that they're saying that the Pennsylvania Supreme Court, all this stuff, it can go up to the U.S. Supreme Court. Statement of the case. Let's go through this. This is interesting. Statement of the case. Alex Jones has staked a fair claim to being the person most unpopular in Connecticut. Staked a fair claim. He knows it. He founded a nationally renowned media organization called InfoWars, broadcasts daily, reaches tons of people. Many people have labeled him a, quote, conspiracy theorist, as I kind of just did here. In the years following the 2012 school shooting, left 21st 20 first and second graders and 6 teachers dead. Jones and his organizations entertained various controversial figures. They posited theories about whether the shootings actually took place or whether they were a contrived false flag operation, which is an event created to manufacture hysteria. Jones himself personally posed the same questions over the years, but he eventually stated that he no longer questioned whether the shooting actually took place. Respondents, parents, and relatives, they all are upset about it. Of course, they're suing him. Thus, respondents and petitioners claiming, among other things, they're saying there are unfair trade practices, defamation, and infliction of emotional distress. As we saw, Eric Swalwell also has some emotional distress, so we see that come up from time to time. Continues on, respondents demanded that there was metadata associated with thousands of emails. And it looks like here they discovered that there was unopened child pornography, which the petitioners did not know about. Jones concluded that someone bent on doing him harm had sent the emails to him with hopes that prosecutors would eventually see it, exposing him to prosecution and incarceration. So then Jones quickly focused his suspicions on one of the respondents' lawyers, a former federal prosecutor with political ambitions. He chose to air his suspicions on his daily InfoWars television show. He informed his audience that someone had embedded child pornography and hate emails sent to him, excoriating him for his coverage of the Sandy Hook stuff. He said that he had to turn those emails over in discovery and that the former federal prosecutor had contacted the FBI and tried to get him into criminal trouble despite the emails. Jones then grew more and more outraged on live radio and television at what he perceived to be a deliberate attempt to cause him criminal trouble. He went into a profane and emotional tirade directed at the individuals he thought were responsible. He offered a $1 million reward for evidence that revealed who was responsible for sending him the child pornography. He also declared war and repeated his offer of a bounty directed at whoever sent the emails. You're just trying to set me up with child porn, he said. I'm going to get your ass. $1 million. $1 million, you little gang members. $1 million to put your head on a pike. $1 million. He uses a profanity word there. He says, I'm going to get your ass. You understand me now? You're not going to ever defeat Texas, you sacks of shit. So get ready for that. Oh, Alex Jones. All right. So despite his outrage, however, Jones unmistakably expressed that he only wanted people to act lawfully. Oh my gosh. And now I ask my listeners and everyone, you claimed I sent people. I never sent anybody, and I want legal and lawful action. But I pray to God that America awakens. Will Texas be defeated? You will now decide this is war. Oh man, it's a good thing that he did not speak at the Save America rally, isn't it? A few days later, respondents filed motions asking the trial court to review the broadcast. Next day, the court held a hearing after argument. It sua sponte, that means on its own, the court elected to impose discipline without the benefit of a further briefing. They denied Mr. Jones and defendants the right to have their special motions to dismiss heard as a sanction, citing the court's inherent supervisory authority over the litigants. Expedited appeal, blah, blah, blah. All right, so Alex Jones went on an epic rant. I've got like tears in my eyes. That's so funny. Just going bananas. And his rants are hysterical, by the way. If you haven't seen one of those, they're something to behold. He goes off and he's got some serious energy behind it. So he goes off on this rant, goes back into court. Court just says, all right, that's a hard pass from us, brother. You're getting sanctioned. Now he's upset that his free speech in his television show, which I agree, I think he's free to go out and rant and rave whatever he wants. Now, when he starts saying, I'm going to put $1 million bounty on somebody's head, that's when you start to get into some tricky area here. And so we're going to see what the Supreme Court ultimately does with this. Reasons for granting the petition. They're saying that the Connecticut Supreme Court created a new exception to the First Amendment, which we don't like. We do not want new exceptions to the First Amendment. It's good as is. The Connecticut Supreme Court characterization of Mr. Jones' speech as an imminent and likely threat creates a new First Amendment exception. The Supreme Court fashioned an old rule that carves out a mixed motive analysis of its due process analysis and deprives litigants of any fair notice or meaningful opportunity to be heard on the merits. And so this whole thing has been submitted in front of the U.S. Supreme Court, and we'll see where it goes. The respondents are going to be able to file their response. It's due by March 22nd, so we'll continue to follow along on this story. And that's Alex Jones. All right, so let's change gears a little bit. Let's talk about Governor Whitmer. We've spoken about Governor Whitmer before on the show in the context of the the alleged attempts to capture her. Remember, there was a whole story where there were individuals in Michigan who were trying to essentially kidnap the governor. So we've talked about her in that context before, but she's back in the news. We spent some time on this channel talking about Governor Cuomo over in New York, who is under a lot of investigation, a lot of hot water for multiple things. Of course, we're talking about the sexual harassment scandal. But in addition to that, he's got the nursing home debacle, which in my opinion is a way bigger story. Well, some of the same issues are happening in Michigan, it looks like. Now there is a new Macomb County prosecutor who says that criminal charges are possible against Governor Whitmer for Michigan's own nursing home deaths. This story came over from WXYZ.com, which is a news station over there. It says criminal charges could be in the works against Governor Gretchen Whitmer over putting COVID patients inside nursing homes used as hubs early on in the pandemic. And so I wanted to just pause on this briefly. Remember, I've been trying to apply the same standard equally across the board. Even when we were talking about Cuomo in New York, I think the appropriate standard here is, look, if you're in the middle of a pandemic, you're making snap decisions, you're trying to move patients around and move bodies around, I understand that people are going to make mistakes in that context. Not going to beat up too hard on anybody who's trying to help during the pandemic, because it was a mess. I lived through it. So did you. It was not an easy situation to navigate. If you're the governor and you've got a lot of people, you don't know what to do with them, I can understand making a mistake on that point. And so I'm not upset particularly about that. I am sort of disgusted that somebody would make a decision that's so asinine as to put people that we knew who were elderly and sick and the most vulnerable together with other COVID patients. I think is idiotic and a bad judgment, and something that these politicians easily could be impeached over and certainly not reelected over, because it's just poor critical thinking and poor decision-making skills, in my opinion. Of course, I'm not in their shoes. I don't know what it's like to be the governor of a state in the middle of a pandemic. Maybe that's the best option they had. I don't know. But I don't think it amounts to criminality there. Where the line gets crossed is when they cover it up. So when Cuomo and his office then suddenly started manipulating the numbers and sort of counting things differently, saying, well, if they died at a hospital and not a nursing home, even though they got transported out of the nursing home and over to the hospital, we're not going to count that as a nursing home death. We're going to count that as a hospital death. Stuff like that, I think, is very, very close to being fraudulent. And that type of stuff is criminal, in my opinion. Now, in this case with Governor Whitmer, I'm not sure that she's at that threshold yet of criminality. We'll see, but this is the first inkling, because there is a new Macomb County prosecutor, guy by the name of Peter Lucido, who says people who lost loved ones to COVID as residents or staff inside nursing homes should get back should go back to get the vital information about the circumstances of their death and take that to the local police and make a complaint as a wrongful death. Okay, so this is an elected person who used to be a senator in Michigan, who is now a county prosecutor for Macomb County. Says, yeah, go to the nursing home where your loved one died, get the vitals, get the information, get the statistics, the circumstances surrounding their death, take it right down to the police, file a complaint. He's saying it should be a wrongful death charge from a prosecutor. This is not a political news pundit. Okay, this is a prosecutor in this county. So basically he's indicating if you do that, he's going to prosecute the case. All right. He says he can't do it on his own, though. He says with HIPAA laws, can't get that information on his own to start an investigation. He started looking into this last year as a state senator. He issued a statement in August that said more than 2,000 residents and 21 staff died in nursing homes. Those were 32% of all deaths. He's asking people to go back to nursing homes, gather vital information surrounding deaths, take it to a local police to file a wrongful death report. He will be meeting with Macomb County Police to instruct them on how to process and verify the information and bring it to his office. He says, why did my mom or why did my dad, my brother, sister, or aunt die? Was it because of a policy? By bringing COVID-infected patients that spread to my mom that killed my mother, he said. After becoming a prosecutor this year, he asked fellow county prosecutors to form a blue ribbon committee for consistency investigating these cases. That association as a group declined and said Lucido should make the request to the Michigan Attorney General and the feds. He provided letters showing that he did last May. So this guy's on it. I mean, he's actually communicating with county police to say, if you get one of these claims that come in, here's how to handle it. Here's how to process it. Just like he would with anything else, any new law that comes through. It's very interesting. The Attorney General, however, said that they're not interested in pursuing this. They said there's not a proper basis to open up a criminal investigation. The U.S. Attorney said they would look into the request. He says, I didn't receive a very warm welcome. This is not political, everyone. This is about people who passed away at the behest of a policy that was created by the governor, said Lucido. Governor Whitmer released a statement, said our top priority from the start has been protecting Michiganders, especially seniors and our most vulnerable. The administration policies carefully track CDC guidance on nursing homes. We prioritize testing of nursing home residents and staff to save lives. Early in the pandemic, the state acted swiftly to create a network of regional hubs with isolation units and adequate PPE to prevent the spread of COVID-19 within a facility. In addition, we have offered 100% of nursing home resident priority access to the vaccine. Both the former head of AARP, as well as an independent U of M study. The comments are shameful political attacks based in neither fact nor reality. Even his former colleague, Republican Senator Ed McBroom, said they have not seen any evidence or testimony that a nursing home was forced to take someone against their will. And that's the reason why Mr. Lucido's colleagues have publicly rebuked this politically motivated waste of taxpayer dollars. Michiganders are tired of the petty partisan games and won't be distracted by them either. So I was a little bit curious as to what he wanted to charge the governor with, or anybody in her administration with. So we were poking around some of the statutes. This is over from Michigan. This is the manslaughter charge. I got a bone to pick with the people who draft the Michigan laws. This is I think this is the full law. It's section 750.321 from the Michigan legislature. And it says here, manslaughter. This is how they define manslaughter. Any person who shall commit the crime of manslaughter shall be guilty of a felony punishable by imprisonment. All right, so are you going to tell us what the crime of manslaughter is? Is that elsewhere in the statutes? I didn't see it, so kind of a garbage statute. But it's in there. It's in the code, right? You can go find it. I'm probably going to get skewered by some attorney, say I was looking in the wrong spot. That's okay. We have another one, willful neglect of duty. How about this statute? This is sort of what a statute should look like. When any duty is or shall be enjoined by law upon any public officer or upon any person holding public office, every willful neglect to perform such duty, where no special provision shall have been made for the punishment of such delinquency, constitutes a misdemeanor. All right. These laws are terrible. They're just terrible. What the heck did that even say? Michigan. Come on. Update your laws. It's 2021. When were these written? Terrible. Here's another one from the U.S. Code that we can actually make a little bit of sense of. This is manslaughter under the federal rules. It says manslaughter is the unlawful killing of a human being without malice. Okay, we can do something with that. Unlawful killing of a human being without malice. That means that you didn't intend to kill him. You don't have anything hard in your heart about that. They just died, and it wasn't lawful to kill that person. They define two types. Involuntary manslaughter would be the one that we might be thinking about. In the commission of an unlawful act not amounting to a felony, or in the commission in an unlawful manner and without due caution or circumspection of a lawful act which might produce death. So the governor had the ability to make things, so it was a lawful act. It wasn't an unlawful act. So we're in the second half of this statute. It says if the commission, in the commission, an unlawful manner or without due caution or circumspection of a lawful act that might produce death. All right. So if you're guilty of involuntary manslaughter, imprisoned not more than 8 years. So kind of an interesting hint from this prosecutor from Macomb County. I don't think it's going to go anywhere. I think that even if somebody came and said, yeah, my grandma died in a nursing home, not sure that they're going to be able to charge anybody with a crime on this. It does feel a little bit political to me, even though it's a bummer. All right, we've got Jeremy Matrita says, speaking of manslaughter, when is Congress going to modify the laws to include womanslaughter? I know, Jeremy. What is it? We're going to have like a whole nother alphabet. We're going to need all those subsections A through Z. Is that going to cover all of the different gender identities that exist now? Can we get them all done in our alphabet? We're going to need new code books for all the definitions. All right. So last segment of the day. Kind of giddy today. Just been giggling myself to death over here. All right. So this is an interesting story. Now that we are kind of hopefully on the tail end of the pandemic, Courts are getting back in session. We're seeing that a lot of the Derek Chauvin cases are happening in person, but other courts are still going through on Zoom proceedings. And there was a pretty interesting Zoom proceeding that just took place very recently. It involves a person who is the defendant, who's a person who's being accused of a crime. He was on a court proceeding, and the victim of his crime was in the same room, was in the same building, was in the same residence, let's say. They were in the same house. That's a problem, okay? When you get charged with assault, and you have a victim who is the victim of your crime, or the accuser, if you prefer that word, you're not supposed to be hanging out together. Okay, one of the first things that the court does is they set release conditions that say you're not to return to the scene of the crime, you're not to go back to the Target where you stole that candy bar, you're not to call your ex who you just verbally threatened or whatever. You're not supposed to communicate with any of those people. In this case, you're certainly not supposed to go back to the same residence. This story came over from Law and Crime. We actually have the video I'm going to play for you. It is, I have not seen anything quite like it before, but we are going to play that here at the end. Let me give you some background here. Michigan court hearing, speaking of Michigan, a Michigan court hearing involving assault charges was postponed earlier this week after the alleged abuser was discovered at the home of the alleged victim during the remote hearing itself. What? Kobe James Harris, 21, he's accused of assault with the intent to do great bodily harm, less than murder, against a woman. The charge stems from a February 9 incident that occurred in Michigan. Conviction carries a maximum of 10 years in prison. The reported victim, Mary Lindsay, during the digital Zoom hearing on Tuesday, said the assault happened after the two, who were dating at the time, had a short argument. Roughly 7 minutes into the hearing, however, State Attorney Deborah Davis, who's the prosecutor, noticed something isn't quite right. While quizzing Lizzie about the original 911 call over an objection from the defense, Davis spoke up, told the court she believed Lindsay and Harris were near one another based on the former's verbal cues and body language. So this is a prosecutor watching her witness over a Zoom proceeding and just gets the hint, gets the idea that maybe the guy's in the room right there in a formal court proceeding where they're asking questions, right? It doesn't sound like they're just scheduling court dates. So the defendant now is in the same room, presumably. So when Mary Lindsay is being asked questions, he's, waving his finger or doing something. Prosecutor picks up on that and says specifically, Your Honor, I have reason to believe the defendant is in the same apartment as the complaining witness right now. I'm extremely scared for her safety. The fact that she's looking off to the side and he's moving around, I want some confirmation that she is safe before we continue. In the video uploaded, you can see the judge, Jeffrey Middleton. Harris can be seen shaking his head apparently to indicate no. Mr. Lindsay, where are you right now? The judge asks. She says, I'm at the house. What address? It's my house. What's the address? Lindsay eventually gives the address to Sturgis, before the judge goes over to Harris. Judge Middleton then confirms that Harris is dialed into the digital conference using a phone. After that, he asks Harris to go outside and take pictures of the address, which clearly and audibly catches him off guard. Why? I don't even think this phone has a charge for that, sir. I'm at like 2% right now. I'm hooked up to this wall charger right here. Davison interrupts the note to note that the police are waiting outside of Lindsay's door and knocking to be let in. Alleged victim gets up, goes and speaks with the police. We may need to adjourn this, Your Honor, Davis tells Middleton. We would ask that the bond be canceled. Roughly 2 minutes in. And let's go into the video so we can just get it. We don't need to read it first. Here is the video from the Zoom proceeding.
Your Honor, I have reason to believe that the defendant is in the same apartment as the complaining witness right now, and I'm extremely scared for her safety. And the fact that she's looking off to the side and he's moving around, I want some confirmation that she is safe before we continue. And that wasn't hearsay. We'll get to that in a few moments.
Miss Lindsay, where are you right now?
I'm at a house.
What's the address?
It's my house.
Who's she looking at?
What's the address?
108 West Hatch.
Okay. Mr. Harris, where are you?
703 East Lafayette, Your Honor.
See the officer on the phone?
All right, what are you on, a laptop or a phone?
Me?
Yes.
Phone.
All right, I want you to walk out to the front of the house, show me the house number on the house.
Why? I don't even think this phone has the charge for that, sir. I'm at like 2% right now. I'm hooked up to this wall charger right here.
Your Honor.
We're knocking at the door right now for Miss Lindsay.
What?
The police are at Miss Lindsay's apartment right now, knocking on the door.
All right. Ms. Lindsay, would you go answer the door?
Yeah, give me 1 second.
You take your phone with you so that I know you're okay.
Hi.
Colby's here.
We're going to skip forward here in a minute. She's talking to the cops. That guy's got a pretty good poker face. Colby Harris hasn't moved yet. Now she gets off the line. Goes dark for a little bit. Kobe down there is kind of looking around.
This is a issue we didn't have when we had live court. This is the first time, to my knowledge, if he is in the same venue, that this has occurred. Kudos to the Sturgis Police Department for following up on this.
All right, and there he is. There's now
The
it's
bond is canceled. If you have $10 million, you can't bond out. In addition, the prosecutor is probably also going to charge you with obstruction of justice. It may be a situation of you and Mary want the bond conditions lifted, you want them lifted, she does not. We're serious as a heart attack. It's the first time I ever had anybody sitting in the next room potentially intimidating a witness and assault great bodily harm. All right, don't say any more about it. Your bond is canceled. You're digging your hole. You've hit bottom and you're continuing to dig. Officers are directed to take him into custody on a bond violation. Bond is canceled. We will reschedule this hearing for another date. Ms. Lindsay, the prosecutor's office will be in contact with you to reschedule this.
not good, not too good. So a couple things here. You know, in Arizona, at least, if I can speculate on it, he'd be charged with a number of additional crimes. One would be interference with judicial proceedings. One would be a violation of basically your release conditions, which is a similar type of an offense. He returned back to the scene. He had contact with a victim of a case, presumably when his original release order said you're not allowed to do that. He, lied to a judge on an open proceeding, saying he was at a different residence, obstruction of justice. He may have been coaching a witness tampering in the middle of a proceeding, and the judge just canceled his bond. So he's going back into custody as well. Now, listen, this is something, to be fair to him and to the female here. You know, in this case, I did not see anything that looked like she had the wherewithal to really be able to object or to really voice an opinion. Didn't get her perspective on this at all. But I will tell you, this happens a lot in criminal law. Somebody will be arrested. It's a husband and wife. They live in the same residence. They got the same kids. And so the husband, typically is the one who's charged. He wants to go back home, but his release conditions say you can't go back home. So what do you do about that? Now, he's got nowhere else to go, right? A lot of people don't have the resources to go buy a separate residence or go rent a separate property. They live on commingled funds. It's community property between a husband and a wife. Now, this obviously was not that case, but I'm just fleshing this out. So what do you do? Well, some people do exactly what he did. They just go back home. And they sort of they gamble a little bit and say, well, nothing's going to happen again. My wife's not going to call the police again. We're not going to get into another fight. There's nowhere else for me to go, so I have to go back home. That is not legal advice. That's not something we advise. The court order says don't go back home. So if you do that, you're in violation of a court order, and that could be a new crime. But some people have no alternative, and that's just what they do. Not advised. Now, typically, this doesn't happen this way, where somebody would stay at the residence and join in on a conference call. Right? You'd go somewhere else. You go to your parents' house, you go to a friend's house, you go to your office, go to a Starbucks. You don't do it from the same building. And you certainly don't do it where you're sort of coaching somebody on what to say. And this prosecutor picked up on that. Deborah Davis obviously knew that, she was looking around and could just tell that they were communicating with one another. And so to her credit, she was able to find that out. He's in a world of hurt. I didn't hear anything from his defense attorney. I didn't hear anybody speaking up, but this judge said specifically, stop talking, right? You're in trouble. And so the bond is going to be canceled. He's not going to get out of custody, probably for the foreseeable future. Judge may let him sit in custody for another 35, 45, 60 days and learn about what he did before revisiting, reorchestrating a potential bond. But the prosecutor is going to hit him with a whole bunch of new charges. And since he committed new offenses while he was on release on a prior bond, he may not get out of custody until the case is closed, which is a major problem for him, presumably. So is there a right way to handle this? Yes, there is. So if you were in this situation and you wanted to return back to your residence or have contact with the alleged victim of a crime, there is a formal process for this. You can't just go back home. You got to go and you got to file what's called a motion to modify your release conditions so that the judge can change the rules, can say, yes, you can go home to pick up some stuff. Yes, you can go home, but you're not to engage in any verbal harassment or any insulting behavior or any of those things. If that happens, you got to leave immediately, right? They can fashion some restrictions on this, but this is not a good look. I've never seen anything quite like this before. I have seen people who will show up at court with their victim, or with the alleged victim, right? A defendant will come to court and they'll bring in the victim. And you're going, what are you doing? You can't be together. What are you guys doing? But it's because people call the police a lot and they think that the police are going to come and just calm things down. And that's just not typically how it works, right? So you have a couple that they really want to be together. They're in a very dysfunctional relationship sometimes, or they could be in a great relationship and they want to be together. The police came and they're interfering with that. And they don't understand that you need to get a court order in order to start getting things back to normal. It just sort of is just something that people don't even think about. So, this guy thought he was being clever. Obviously, he's going to get hit with a slew of new charges. He's going to be in custody for the foreseeable future. So this is just a word of caution for anybody who's in this current scenario. File a motion to modify your release conditions and wait until it's granted before you go back in a situation like this. All right, some questions over from locals.com. This is watchingthewatchers.locals.com. Our first question comes from News Now Wyoming. Says, Robert, I think this is my favorite story to come out this past week. You can't even go to a different house during the hearing. Yeah, I know. I mean, like literally the same hearing. And I couldn't tell, that woman seemed like she was very shaken, they call it, sort of a battered woman syndrome, right? Where she looked petrified. The judge was even trying to ask her about her address, and she couldn't even kind of connect the dots on that to sputter that out until she was prompted a second time. And so, she seemed to me like somebody who he might have been trying to manipulate for the purposes of this hearing, which is why he would have to be in the same building. Or he's just dumb. I don't know. It could easily be that also. But yes, should not be in the same residence, especially during a live court proceeding. We have chairman of the board says, from Michigan, I feel personally attacked. Leave our laws alone, Rob. Kidding. Chairman, they're terrible, man. I was looking through them this afternoon. I'm like, what the hell are they doing? It's really convoluted and it's all old and it's like just the worst. Attorneys sometimes like to feel special because they can decipher this really convoluted language that doesn't make any sense. I think it's stupid. I really can't stand it. I'm a lawyer. I'm licensed in 2 states. I can read it. I don't like it. I don't like to read it. It's useless. You can take a whole paragraph and synthesize it into one sentence and just apply that law. I don't know why we have to have these laws from, a million years ago that were written in a different language. Michigan. Drives Drives me bananas. Thanks, Chairman. Good to see you, my friend. We got Hack Consulting in the house. Says, I would actually argue something like this does indeed occur in live court settings. If a defendant has doubt, they will feel intimidated by the future of not having protection. It is just that these things are not so noticeable except in unlive court. So I have seen something like this actually happen in court. I mean, I just explained that you'll have somebody who shows up to court with their alleged victim together, even though they're both not supposed to talk to each other. So people just sometimes just lose sight of how this stuff works. You know, it's complicated. Some of the stuff that might seem very rudimentary to you and me is not for some people. And so, you know, that guy's going to learn a very expensive lesson. We have Danger Mouse in real life. Danger Mouse IRL says, what's your position on mandatory workplace vaccinations? I am against them. I haven't discussed it with my business partner yet, but we're not mandating workplace vaccinations here at this firm, right? We've got, I think, 21 employees, 21 team members here now. They want to get vaccinated. If they want to put something into their body, they're free to do that. I'm not going to mandate it one way or the other. And our last questions come from Ma Fox. Says that if these proceedings were in person, he'd probably have tackled the defendant, assuming he'd approached the witness. Yeah, so... I don't know. I honestly don't know what he was thinking, but it was an interesting one. So I wanted to share it with you. Yeah. I mean, you can't be doing that stuff. And if he's in court and he's like scolding her during the line of questioning, you can see that. But down here, if he's giving her, you know, a little, if he's doing one of these here, like 1 for yes, 2 for no, and he's got it down here over here. Oh yes, Judge, I'm paying attention. He's going like this to her. Hey. Say yes on that one. Say no on that one. Not good. Look, honestly, I hope that young lady is okay. She looked pretty not okay to me in that situation. Hopefully she's doing better. Hopefully he learns a little bit of a lesson, gets his life back on track, and becomes law abiding. So we'll see what happens there. Thank you, Ma, for the question. And thank you to all of you on Locals who submitted those questions. Locals.com is a pretty cool platform. We're building up a community over there of people who like to communicate about free speech in a platform that I think helps to cultivate that type of conversation. So I want to thank those of you who are already over there and supporting the program. I go through this at the end of every show, but it is important because this is sort of, I think, the future of us being able to communicate about these issues. We've got Ma Fox in the house. Saw him today. Miss Faith is back there right behind me, killing it. We got Liberty or Death in the house, who chimed in today. We have Socially Troubled. Toots Magoost I saw posted earlier today over there on the platform. Who else do we have? We've got Ham Handed in the house. Ditka's Bears. Pinky too, we see fairly regularly. We got Realtor Patty who chimed in today. Saw her. Thank you, Realtor Patty. Good to see you. Want to know who else we have? We've got Michelle Monique, Paula MK85. We've got No Doubt in the house. I'm a Lemon, Echo House, See the Veil, Kenny B1B. We got Drag, Carolina Flyin', Fang 3. We got a couple people who signed up last night. It looks like we got It's Ed. What's up, Ed? Welcome to the show. We've got at Carlos142857, who also signed up over at watchingthewatchers.locals.com. Let's say hi to Stookie, Anki Woe. We've got Dana Nanoman. We got I Onion in the house, Norovira, and Cryptomancer also all joined up. And there's a lot of great things you can get over there. Here's just a snippet of it. Of course, grab my free book. It's called Beginning to Winning, How to Fight Your Case and Succeed in the Criminal Justice System. You can also buy that online on Amazon if you want a paperback copy of it. All the slides that we went through today are going to be available. We're going to post those as well. Copy of the impeachment proceeding documents and my existence system is over there if you want to get a copy of it. Very good links and great conversation with great people. So join us at watchingthewatchers.locals.com. And lastly, but not leastly, I'm a criminal defense attorney. See that sign right there? It says R&R Law Group. We're in Scottsdale, Arizona. We offer free case evaluations. We love to help people who have been charged with crimes, good people who've been charged with crimes, find safety, clarity, and hope about their cases and also their futures. And we can help people with anything. Anytime anybody's in trouble with the law, whether it's a DUI, a misdemeanor, urinating in public, disorderly conduct, criminal damage, domestic violence, some of the major felony cases, possession of narcotic drugs, dangerous drugs, prescription drugs, marijuana violations are not around anymore, thankfully, but there are a lot of other drugs that cause people some problems. Felony assaults, vehicular homicide, all of them. Anything and everything in between, we can handle it. We've also helped people clear up old warrants, remove mugshots off the internet. restore their rights, right to vote, right to possess a firearm, all of those things. Very good at what we do. Got an awesome team of people here that we've cultivated over the years that love to help people. And so if you or anybody that you know or love has been charged with a crime in the state of Arizona, we would be honored and humbled if you sent them our way so that we could help. We'll make sure that they come to our office when they leave. They'll leave better than they came in. And that's it for me, everybody. That's my last takeaway. That's my last call to action. If you know anybody, send them our way. We'll be very grateful. But that's it. We're going to be back here tomorrow, same place, same time. Before I go, I want to remind everybody, we're going to hop on Clubhouse right now. Literally, I have my iPad right below this camera. I'm going to pick it up, and we're doing live Q&A on Clubhouse. I don't know if anybody's in the room. I never know, but we'll see. And if it's just two of us, that's all right, because I love to talk to you. Let's do it on Clubhouse. The link is in the description below. We'll be back here tomorrow, same place, same time, 5 p.m. Arizona time, which is Mountain Time, 4 p.m. in California, Pacific time, 6 p.m. Central in Texas, 7 p.m. on the East Coast. And for that Florida man out there, everybody have a very lovely night's rest. Have some good dinner if you haven't eaten, and I'll see you right back here, revved up and ready to go tomorrow. Bye-bye.